All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Right. Good morning, everyone, and welcome to our virtual arguments on this Zoom remote platform. We have 3 cases set for argument this morning. We have tested and worked through the technology, but I hope all will be patient in the event that we do experience some technology glitches during the argument. We're doing these arguments, as you all know, in light of the COVID-19 pandemic to keep everyone safe. And they're being live streamed so that the public has access to them. So good morning. Our first case this morning is Mingle versus Oak Street Apartment. Are counsel ready to proceed?
Yes.
All righty. Mr. Coniglio, is that the correct pronouncement?
Yes, Your Honor.
All righty, you can begin.
Thank you, Your Honor. And may it please the court, Joseph Coniglio for appellant Robin Mingle. I'd like to reserve 3 minutes of my time for rebuttal, please.
All right.
Your Honors, we believe that Appellee Oak Street Apartments did not show either that there was an ongoing obligation for Ms. Mingle to remove unauthorized occupants or that Mr. Canty was an unauthorized occupant. The plain meaning of paragraph 3 of the parties' settlement agreement is clear in its first provision that the obligation Ms. Mingle had to remove unauthorized occupants was time limited such that any unauthorized occupants had to be removed within 7 days of the agreement being filed. The second clause of that provision defines an unauthorized occupant as someone who had been residing with Ms. Mingle for 14 consecutive days at the time the settlement agreement was filed. The context of the
Mr. Coniglio, you have 2 arguments that you're making, and I take it you're presenting them in the alternative. That is to say you prevail on either one of them for independent reasons. And one thing that interests me is, and I don't ask you to go to the second argument, but would the relief that you're asking for be the same in both? And if so, would the second argument require a remand for further findings, or could you just prevail on that ground without any further action? I'm just trying to pin down whether we need to decide both or we can decide either. And if so, is there any difference in the relief if we decide one or the other?
Thank you, Your Honor. We believe that with respect to the 2 questions as to whether or not Ms. Mingle had an ongoing obligation and whether or not that obligation was violated by having Mr. Canty as an unauthorized occupant, both of those questions are necessary findings that landlord must make. And if they lose on either one, relief should be granted to Ms. Mingle. The other claim we'll make is that the court abused its discretion by not allowing evidence of Mr. Canty's unauthorized occupancy. And with respect to that claim, perhaps a remand would be justified. However, I would note, of course, that this court has already asked Judge Satterfield to go back and make factual findings and conclusions of law, and we would submit
Mr. Coniglio, I'm sorry to interrupt you, but I wanted to take you to your first argument briefly. And then we could come back to the second point about whether a further remand is necessary for factual findings. Because I'm having trouble with your interpretation of the language of the settlement agreement. You say that the sole requirement of paragraph 3 was, not to put words in your mouth, but as I understand your argument, you're saying the sole requirement of paragraph 3 was a one-time, essentially, removal of any unauthorized occupants. That seems to be how you're reading it. And if so, I'm not clear how you square that removal within 7 days language with what to me seems to be the language in paragraph 3 imposing essentially an 18-month, as I would read it, an ongoing 18-month requirement to ensure that there were no unauthorized occupants in the unit. Why
Thank
is
you, Your Honor.
my reading not correct?
So we do believe that the obligation in paragraph 3 was time limited such that any unauthorized occupants that were existing at the time the settlement agreement was filed had to be removed within 7 days of the settlement agreement being filed. We read paragraph 4 largely as pertaining mostly or most relevant to the obligations in paragraphs 1 and 2, which are not time limited, and say that Ms. Mingle had to remove, prevent undue traffic that interfered with the residents' rights of quiet enjoyment, prevent criminal activity. So paragraph 4 is mostly relevant to that, but it's also relevant to paragraph 3 in the sense that if Ms. Mingle had failed to comply with her obligation to remove unauthorized occupants within 7 days of the settlement agreement being filed, that could have been enforced by landlord throughout the term of the agreement, such that if any of those persons who had been unauthorized occupants at the time the settlement agreement was filed were subsequently unauthorized occupants again, they would have, Ms. Mingle would have had to have removed them. And had she not, she would have been in violation of the settlement agreement throughout its entire 14 months, or excuse me, 18-month duration as specified in paragraph 4. So
No,
Your
I
Honor,
think you might have misspoken earlier, Mr. Coniglio, although I think what you said reflects your overall interpretation of the agreement. You said that paragraph 3 defines unauthorized occupant to be any person residing in the premises for 14 consecutive days, and then you added at the time of the agreement. So it doesn't actually say that, but I take it that that is your reading based on the remove all unauthorized occupants within 7 days of the filing of the settlement.
that is
Yes.
correct, Your Honor.
Yes. You know, I definitely understand your linguistic argument here. The agreement says what it says. It's just difficult for me to think that that's what any reasonable person, including the parties at the time, would have thought it meant. And I wonder whether you think the case law and our objective reading of contracts and the like precludes the conclusion, which I think seems to be the correct one, which is that it doesn't mean what you say it means. Does our case law preclude that finding, that conclusion?
Thank you, Your Honor. So we believe that the contract is unambiguous. And I think that that's landlord's view as well. And we believe for that reason it should be reviewed de novo and not for clear error. But of course, even if this court applies the reasonable person test and finds that it is ambiguous, that's still a de novo review. And our view is that Ms. Mingle's interpretation is clearly the more reasonable run, as distinct from the text and context of the agreement, which factor into the plain meaning, simply because it would have been impossible for her to remove any subsequent unauthorized occupants within 7 days of the agreement being filed. And landlord's interpretation that is to suggest that the agreement meant that she had to remove unauthorized occupants within 14 days, which appears nowhere in the agreement. So we think that the absurd result here is much more on landlord's interpretation than it is ours. And contrary to the arguments made, our interpretation does not render paragraph 3 meaningless. What it says is that Ms. Mingle had a time-limited obligation. And the fact that she performed it and there's no dispute that she violated that obligation doesn't mean it's meaningless. It just means that she was in performance. So, and furthermore, we would suggest that there was no intent finding. I can't speak to landlord's intentions when they made the agreement, but there was certainly no intent finding on our end that Ms. Mingle understood herself to be binding herself to an ongoing obligation. The court made no such finding as to intent. And I would suggest that this court suggests that intent is essentially irrelevant, even when applying the reasonable person test. There's some maybe some conflicting precedents there, but we certainly don't think that's going to be a dispositive factor here, even if the court had found, which it didn't, that Ms. Mingle had an intent to bind herself into an ongoing obligation.
Well, I just think that there may be some support for the notion that language may be ambiguous, even when there appears to be a plain reading of it. And as I say, I definitely take your point that paragraph 3 says what it says and does not say and you must remove any other, and you must not allow any other unauthorized occupants during the term of this agreement. It doesn't say that. It's just difficult to think why, in fashioning this settlement agreement, either party would have thought that it meant anything different. But I understand your point. I did want to ask you, though, about the evidence regarding the Ricky Bob or Ricky Canty, and in particular the evidence that he was described in two different ways. He was either tall and lanky or he was very short, suggesting that witnesses were talking about different people, or declarants were talking about different people. My question is was it necessary to find a breach of the agreement for, let's set aside the first point about what paragraph 3 means. Was it necessary for a finding of breach that the individual involved be Ricky Bob or Ricky Canty, or just anyone who was residing in the apartment for 14 days unauthorized?
Well, we believe that in light of the lower court's opinion, they certainly found Ricky Canty was the individual that had resided there for 14 consecutive days. So if there are no evidence to support that, it's possible that there was another individual, but that would have to be alleged and found by the court, which it did not do. And I would suggest that this gets at a broader issue of the sort of specific and particularized evidence under Williams that's necessary to show unauthorized occupancy. And there was a clear identified individual, and we would suggest that unless those facts, those type of particularity can be provided, that suggests that the sort of evidence provided is not the kind that will address consecutive unauthorized occupancy that this court has suggested is needed under Williams.
What is lacking in the trial court's findings here, in your view?
Thank you, Your Honor. Well, we would just suggest that it's not clear whether or not Williams itself put forward a sufficient condition for determining when authorized occupancy exists, but it clearly said what was not sufficient, and the sort of generalized evidence that does not address the question of unauthorized occupancy in the sense of consecutive days, but merely that a person was seen around the premises. That's not sufficient, simply because, as the Williams court noted, it's consistent with many other possibilities that don't involve consecutive stays. In this case,
well, here, I guess the trial judge does give sort of a lengthy recitation of facts and circumstances, and then a conclusion. Is your concern that the findings are deficient because they don't specifically say the unauthorized occupancy lasted from this day to this day?
That is our Rule 50. I'm sorry, Your Honor.
No, go ahead. You were responding.
That is our Rule 52 argument, but we obviously have an argument that even if factual findings were made to that effect, the evidence was insufficient under Williams to make those findings. And just like in Williams, the sort of evidence that was provided did not address the question of consecutive stays, for 14-day period. In Williams, a 30-day period. In fact, the evidence here was much less than Williams. In Williams, you had registered cars that were parked at the premises. You had mail being sent to the premises. You had the individual identified to the police on an occasion that he lived at the premises. So none of that evidence is provided here, even that level of particularity, which this court found to be insufficient. We don't get anywhere close to that.
Mr. Coniglio, we're sort of moving into what was my second question about, or my first question actually, about whether if we decide this, you can pick one or the other, and what the relief would be, particularly in the Williams issue here. Who has the burden of proof here that would lead us to decide whether additional findings need to be made, or whether somebody forfeited an obligation, a burden of proof to put them in at the first hearing and get findings at that point?
Thank you, Your Honor. We certainly believe that the landlord has the burden of proof both to defend its interpretation of the settlement agreement and to find that that provision so interpreted was breached. vis-a-vis.
Well, I agree with that. Did they put in enough evidence that would support findings so that a remand would have something to deal with, or was it insufficient to begin with so the trial court couldn't make the findings?
We believe it was insufficient to begin with, and we think this is partly explanatory as to why no findings were made. Mr. Vila did not testify that Mr. Canty had resided for 14 consecutive days. And it's therefore not surprising that the lower court only had to go on credibility judgments, credibility determinations, which are evidentiary matter, but they don't constitute specific factual findings. So we think that the evidence was heard, but it's simply just not there. And again, I would note that this is a remand would be the second time this court has went back and asked Judge Satterfield to make sufficient factual findings and conclusions of law. And we think they're just not there.
I've got a hypothetical question that isn't directly involved here, but let's assume a case where we had a continuing obligation, for example, a criminal activity or disruptive behavior and so forth. How does a statute of limitations fit into this analysis? Would somebody be able to say, well, the statute is X number of years and that's tacked on to whenever the claim is made or before the claim is made? How does that relate to this case? Or not to this case, but to say a sub one or sub two?
Well, Your Honor, I would note the procedural posture of this case. There was an underlying lease violation that did not have to do with an authorized occupancy, which was settled by the settlement agreement, which included the violations you mentioned, criminal violations and traffic, but also the unauthorized occupancy. And that agreement was in place for 18 months, pursuant to paragraph 4. So assuming the lease, sort of taking the lease separate, the lease has similar obligations in the first two instances. If Ms. Mingle did not breach those provisions throughout the term of the settlement agreement, she would not be able to be. There would be no motion for non-redeemable judgment that would be able to be filed against her because this claim arises out of that settlement agreement.
Well, I guess what I'm getting at is under sub 1, there is a breach that's alleged. Does this have to be resolved within the 18 months, or could that allegation be measured by reference to a statute of limitations that's different from the 18-month period, or extends it?
No. I mean, we don't. Certainly the breach would have to occur within 18 months, but assuming that occurred on 17-month day 30, landlord would still have the right to bring a claim.
Thank you.
All right, thank you, Mr. Coniglio. We'll reserve your 2 minutes for rebuttal as well.
Thank you.
We'll hear from Mr. Cole, please.
Good morning, Your Honors. Let me just first of all apologize for not having the appropriate screen behind me. I tried very hard to master the technology, but I fell just barely short. I hope it's not going to interfere with the presentation.
Mr. Cole, I appeared as a black rectangle one time and I couldn't get anything going. So
we're doing the best we can in this virtual environment. So
understood.
I'm not sure we would even have noticed if you hadn't pointed it out.
So getting back to the first issue in this case, which was the ongoing obligation, I simply don't think that there's any way that this agreement that paragraph 3 can be read without looking at paragraphs 4 and 5 of the settlement agreement in conjunction. It makes absolutely no sense that the parties negotiated a settlement agreement on a case that had been litigated up to a couple of very shortly before a jury trial, and then settled it with an agreement that simply required the defendant to tell whoever was living in her apartment to take a walk for the afternoon on the 7th day, and then could come back and live without consequence of violation of the agreement for the next 18 months. It is crystal clear, based on the entirety of those 3 paragraphs, that the obligation of the defendant was to remove whoever was in that unit within 7 days and to ensure that they did not stay in that unit. That's why the agreement has a definition for how long someone is allowed to stay without being in breach. I think that opposing counsel's interpretation of the agreement, although I think if you're simply looking at paragraph 3 alone, I think paragraph 3 could be read the way they're saying, but in the entirety of the agreement, it is not ambiguous what that agreement means. And that agreement means that an individual who is residing in that unit without authorization must leave within 7 days, and Ms. Mingle is not permitted to have anybody reside in that unit for the next 18 months without authorization. That's the clear interpretation that I have of the agreement. With respect to the evidence that an individual was residing in the unit, let's just talk about the Williams case for a second, because I think the evidence in this particular case is far stronger than the Williams case. In the overview of the Williams case at the beginning, it says, where all of the evidence was entirely consistent with a situation in which one guest visited the tenant's home frequently and never violated the guest stay requirements, the guest's close personal relationship with the tenant did not establish that he stayed in the home for 30 consecutive days for more than 90 days in 1 year. The evidence in this case is not consistent with Ricky Bob visiting on occasion or visiting regularly and not staying in the unit. There are several pieces of evidence in this case which go directly towards proving that Ricky Bob was residing in the unit. Number one, the defendant filed with a statement that she signed and submitted to the government with a witness, a promise that he was staying there for, it says 2 years, but it could have been less. And she testified under oath that she intended to have him allow him to live there for a significant period of time. That is clear evidence that he was living there. That's her own words. And then opposing counsel wants to take that and saying that that's not correct. But if you do that, then it goes into her credibility, and credibility of the witness is the other issue. She testified all over the place during this proceeding, saying that yes, that was her signature. No, he wasn't living there. No, he never did. There's also the testimony of Mr. Villa, who was both an employee of the landlord and lived directly across the street. He testified that seeing the unauthorized occupant there almost every day, and he testified for
Mr. Cole,
Yes,
can I interrupt you very briefly, because my sense as I listen to you point out key facts and highlight them in support of the ultimate holding of the trial court, I'm not sure the trial court's findings were as explicitly laid out to support the ultimate conclusion that there was an unauthorized tenant in the building. I think part of the concern under the Rule 52 argument here is that there's sort of this kind of generalized, yeah, everything they said, and here, therefore I conclude. And I guess I have a concern about whether that is sufficient to support the ultimate judgment here. Your recitation, had it been laid out, I think as clearly in the trial judge's order, may have been a little clearer. But as I read the order, that's not what it really says.
So, Your Honor, Judge Satterfield does reference the, let me see. He does indicate that he found her testimony not to be credible, and he found the testimony of the plaintiff's witness, and he does reference the computer printout from the Bureau of Prisons. That's on page 2. And he indicates that the witness for the plaintiff who resided in the apartment, and he indicates that that witness was credible. That's essentially the the basis of my argument. Those are really the three main points: that she provided information, that he was signed a document that he was going to be allowed to live there, that she recanted the validity of that document and said that he wasn't going to be living there, and that the witness for the plaintiff testified, well, and he found the testimony of the witness to be credible for the plaintiff. Those are the three elements that I'm relying on. And I do think that based on the evidence, even in the findings of fact by Judge Satterfield, are stronger than what is found in the Williams case. Because the Williams case, there was really no evidence inconsistent with the idea that this guy simply visited her all the time. There was at least 3 pieces of evidence in this case that go towards the plaintiff's claim that Ricky Canty was residing in the unit.
Okay. So an additional remand, in your view, wouldn't help further make that clearer. Well, we have your explanation, which helps to some extent, but that's not actually what the order says.
I will acknowledge, Your Honor, that I think that the one piece of evidence that could be useful on an initial remand, I do not believe that it is necessary, is for the testimony of Ricky Canty, because one of the pieces of evidence which was presented, or one of the disputed issues, was what Mr. Canty looked like. And I would also note that the defendant never produced Mr. Canty, even though they spent a great deal of time arguing that he didn't look the way that Mr. Villa claimed that he looked. And I think that on remand, that particular issue could be resolved, but I do not believe that it is necessary to remand for that purpose.
Would plaintiff have had the plaintiff have had the burden to get Mr. Canty there to deal with it, or no?
I don't believe so. I mean, I think we presented, I think the distinction on that was decided by the judge, that our witness was credible as to Mr. Canty's identity. He testified, as the record shows, that he heard him identified several times by name. He stood very close to him and had a very good idea of what he looked like, and he testified to that. The only thing that was inconsistent with that was that the defendant says, rather than being a tall, dark-skinned man with, he was a short, light-skinned African-American man.
I'll ask you the question I asked Mr. Coniglio. Does the identity of this person matter? I mean, the landlord's claim is there was an unauthorized person in the apartment in breach of the settlement agreement. That's the landlord's position. Does it matter whether it was Ricky Bob, Ricky Canty, Joe Smith? Does it matter? It appears
no,
that
any
the
person
court
residing
credited the testimony by the building employee that someone was living there. Someone,
yes,
not
that's
Ms. Mingle, right?
That's correct, Your Honor, and I agree. It does not matter. The only way in which that makes a difference is that the document which the plaintiff submitted as part of its motion was a document signed by Miss Mingle, that Ricky Bob was going to be living with her and had been living with her for the last 2 years.
Well, as to that document,
it could
your
have been anyone.
opponent says, well, that's what Ms. Mingle said, and the trial judge didn't credit her. Ergo, he was not living there. What's your response to that argument?
Well, she can't really have it both ways, Your Honor. Either Ms. Mingle signed a document which she knew to be important because it had to be witnessed by someone. She sent it to a government agency, and then when she's called on it because it works against her interest, she recants it. And I think that the document, I think the court that tried the case determined based on the credibility of the witnesses that she was lying. And that was the reason why the court found that Mr. Canty or someone was in fact living there. She had an intention to violate the agreement, and she understood the agreement to be that she wasn't allowed to have unauthorized persons residing in her unit.
All right, Mr. Cole, is there anything that you wanted to say in conclusion?
No, Your Honor, I'm finished.
You do have additional time. I didn't want to cut you off
Understand.
prematurely. All right, thank you for your argument. Mr. Coniglio, we reserve 2 minutes for a rebuttal for you.
Thank you, Your Honor. I'll try to be quick here. So first of all, with respect to the meaning of the settlement agreement, landlord's argument is entirely one based on context, and I think it's just incorrect. We've never argued that a person could be an unauthorized occupant, be removed within 7 days, and come back. Our view is that future unauthorized occupants would need not be removed. But the point is, if the person was unauthorized at the time of the settlement agreement, they would have had to have been removed within 7 days. And if that person became unauthorized again, they would still have to be removed within the 18-month period. What we're saying, and which is relevant here, is that someone who became unauthorized subsequently would not have to be removed. And that's an obligation that just does not exist. And the fact that what the agreement says may not have made a lot of sense for landlord.
I'm sorry, say that one more time. That's where I lose you, I think, is that last point. Someone who became unauthorized subsequently would not have to be removed.
That's correct.
That statement really seems to be inconsistent with the lease and the whole point of the settlement agreement. I was with you up until that last point there.
Well, no, I mean, this was what I was trying to argue before, and I think it makes sense, is that, landlord's view is that the context renders paragraph 3 to mean, completely against what it says, that the person would have to be removed within 7 days. And his basis for that is saying that that a person could be an unauthorized occupant and then be removed within 7 days. And then that same person could come back and be another unauthorized occupant and would not have to be removed. That is not what our interpretation is holding. We're suggesting that that person, because they were an unauthorized occupant at the time the settlement agreement was filed, in as much as that person came back and was an unauthorized occupant, they would still have to be removed throughout the term of the settlement agreement. But the case that's relevant here is somebody who was not an unauthorized occupant at the time the settlement agreement was filed. There's no ongoing obligation to remove that person. And so again, we just don't think context is sufficient here at all to eliminate the plain meaning of paragraph 3. And with respect to the evidence of the CSOSA form, the court found that was false. So it doesn't support landlord's claim. And in fact, there is a trade-off with respect to that form and credibility, Ms. Mingle's credibility, but it's not the one that landlord suggests. Ms. Mingle, and not landlord, was the one who argued that her statement was false. So presumably, in so finding that the statement was false, the court assumed that Ms. Mingle had sufficient credibility, that she was correct in saying that I had lied on the form. So if anything, that finding supports Ms. Mingle's credibility and not Mr. Vila's. Now, with respect to the question of Mr. Vila's testimony himself, it doesn't, right? I think Judge Thompson is correct. It doesn't matter who the individual is, but there has to be one individual. And, if there was, let's say, Mr. Vila claiming he saw a one-armed, 8-foot man, throughout the period, it would be very clear to suggest he was identifying the same individual, even if he didn't know their name throughout the time. But here, all he's identifying is a tall, skinny black guy. I quote. And that's not at all sufficient to suggest that there was one individual who was an unauthorized occupant and resided for 14 consecutive days. In fact, there were probably many, and I quote, tall, skinny black guys that may have been around that apartment that Mr. Vila had seen. And in fact, Ricky Bogg never actually introduced himself to Mr. Vila, and that's an undisputed fact. And finally, with respect to remand, we just don't see how a remand is justified here. And I think we agree with landlord here. If landlord had wanted to bring additional evidence or witnesses, it could have done that below. And we've already had Judge Satterfield go back and make factual findings and conclusions of law. But the fact is just not testified to, and it could have been testified to, but it wasn't, that Mr. Canty was an unauthorized occupant vis-a-vis him residing for 14 consecutive days. And we don't see how that failure of evidence and therefore of findings by the lower court is going to be remedied by a remand.
Right.
And
Suppose there had
Cornelio,
been a
you-
more specific description, the one-eyed guy who's 8 feet tall, such that you would think, well, it's got to be a single person being described. Would it be enough to say something like what was testified to, that I saw him all the time, every day I saw him? Is that enough to establish that he resided there? Would that have been enough?
I believe it's a necessary condition, but not sufficient, Your Honor. In addition to identifying a particular individual, as was the case in Williams, they had identified this man as a Mr. Campbell. You still need to show that with specific evidence that there was a consecutive stays for whether 14-day period here or a 30-day period. So yes, it would be sufficient to identify, or sufficient to identify one particular individual, but it would not be sufficient to show that individual stayed, through the requisite time, in our view.
Mr. Coniglio, I just wanted to clarify one thing again. You take the position that the paragraph 3 is consistent with 4 and 5, because a person who has to be removed within the first 7 days, the landlord could decide to wait until the 179th day or what have you, and then get rid of them, so that there is at least a theoretical consistency between the two. That's pretty far-fetched. I'm not saying it doesn't work. I'm just saying that if intent, as opposed to plain words and objective this and that, were determinative, I think most people would probably say that the drafter blew it, but everybody knew what the drafter intended.
Well, again, Your Honor, I don't think this court has license to read provisions into an agreement that will end up, evicting Ms. Mingle, simply because, and I agree, it doesn't seem like landlord got what a reasonable person may have wanted out of this, but that doesn't make the agreement any less ambiguous on its terms, in our view.
No, I just wanted to clarify that the consistency that somehow has to be there was what I stated.
Understood. And I guess I would just emphasize, on our view, it's not just the theoretical possibility that an unauthorized occupant could be removed at the, let's say, 17-month. But if that unauthorized occupant who was unauthorized at the time was removed and then came back, in as much as that person is an unauthorized occupant, they would still have to be removed.
Yeah.
That's also how we're reading the agreement. And that is a very real and significant, that gives paragraphs 4 and 5 force, and that is meaningful and does not at all create any sort of ambiguity.
All right, Mr. Coniglio, I didn't mean to interrupt you, but we have taken you a bit over your time with our questions, and we appreciate your arguments. We thank both counsel for your briefs and arguments today. Would also recognize the law firm of Sidley and Austin for taking this matter on a pro bono basis. The court thanks you for your arguments and briefs.
Thank you.
Mr. Cole, we thank you for your arguments and briefs today, and we will take the matter under advisement. Thank you both. And you're free to exit our virtual courtroom at this time as we prepare for the second case. Thank you.
Thank you, Your Honors.
All right, good morning, counsel.
Good morning.
Good morning, Your Honor.
We're just adjusting the clock. This is the second matter on the court's calendar this morning. This is the case of Cargbro versus United States. Counsel, are you ready to proceed?
Thank you, Your Honor. Jennifer Wicks on behalf of appellant, and I would like to reserve 2 minutes
Okay, thank
of my
you.
time. I think first wanted to start with, I think this case, the more I reviewed this case, the more complicated I think it is. And I think if we look at the guidelines from the hospital, which is in my appendix, it doesn't actually tell the officer when to look for valuables. I think the issue is the officer here is opening up a closed container, the fanny pack, and going into the pockets. And
Ms. Wicks, could I interject briefly just to take you back to frame this issue for us a bit? This is a issue where we're trying to determine whether a special police officer, essentially a security guard at a hospital, is acting under color of government actions in conducting, I guess, what some might argue is a routine inventory check. Patients come into hospitals all the time. They have belongings. The hospital wants to collect those belongings and safeguard them until the patient is discharged. How do we go from that kind of routine? Happens all the time in hospitals everywhere, and we don't usually deem that to be within the realm of government action and Fourth Amendment search and seizure law. What is it about this situation that went from a routine, collect your belongings, keep them safe until the patient's discharged, to state action invoking the Fourth Amendment?
I think there's a couple of things I can point to in these facts. One is we have a number of officers sitting there watching this seizure take place. And I think I think there's, in the cases, it's talking about that the officers didn't deter the special police officer from what he was doing. I understand that the hospital has a duty and has a duty for safekeeping of property, but what the officer here is doing, and I mean, what the special police officer is doing is picking up property and putting it into a bag. And at no time, I think what the officers should have done to stop the Fourth Amendment from violation from happening is say, hey, we need to get a warrant to search that. Because he's picking up a fanny pack, which is sort of the equivalent of a purse that a woman might have, and putting it in a bag. So the bag is big enough. There's no reason for him to go into the fanny pack. There's no.
Oh, excuse me. There'd been no arrest, had there?
Right.
Right. So
there's no suspicion of any criminal activity.
Well, then how could you possibly go get some warrant or anything that would make that possible?
Well, I think that's the problem here. They would not, absolutely, under these facts, they would not be able to get a warrant. But
so then what then leads you to say that it's state action if the state almost by definition hasn't been involved?
Because the state is involved. They actually brought him to the hospital. They're sitting there watching him being treated in the emergency room. He's the driver of they're assuming he's the driver of the vehicle because the other patient, the woman in the car, was taken out of the passenger seat. And they're clearly, while they're not investigating criminal activity, the officers are there to gather more information for their traffic report, and to ensure that things don't get worse for either the passenger or the driver involved in the accident. So they're there. I don't think it's a coincidence that there's no property taken off the actually more critical patient. The reason there's a code yellow is because of the more critical patient, which is the passenger. And that's why the special police officer responded to the trauma area of the ER to gather property. So he's gathering property, and nowhere in the hospital's own guidelines and policies does it say when he should be so-called searching for valuables, which is ultimately what he does. He's
Ms.
searching.
Wicks, can I interject very briefly again? Well, you said there's nothing in the hospital's policy. There is some discussion about a potentially different procedure for somebody who's a quote unquote forensic patient. And I don't think that I'm persuaded that Mr. Cargbro was a forensic patient here. Could that have been another, would the outcome be different if, and do you think he was a forensic patient that required a heightened level of procedures here?
I think the outcome wouldn't be different if he was a forensic. I don't necessarily know that the court had enough to determine whether he was forensic or not, in that, I mean, the police accompanied the ambulance. The ambulance is state actors. The police are accompanying the ambulance. They're let into the they're while he's not restrained, they're clearly escorting him. The discussions seem to have nothing to do with the passenger. The focus is on the driver. So I think that's a little suspect.
Rex, you have an individual who comes to the hospital with absolutely no suspicion of any kind of criminal activity. And the hospital has seems to me at least, a very strong interest in making sure that they do an inventory so that they're not going to get accused later of having stolen something while he was on an operating table or something of that sort. And so wouldn't the most natural thing for any SPO in this circumstance to do would be to look in, take an inventory and make sure that they have that, so that kind of accusation would never prevail. And it seems to me that's what happened here. And all of a sudden it turned out, whoops, and then they found this criminal activity implied by the contents. But I don't know what they did wrong in trying to cover that important policy for the hospital.
Well, I think part of the important policy is that they have a safe to lock up the property. So, you know, they have procedures in place that would safeguard property that contains valuables or valuables. So,
okay.
you know, I think.
But you can just imagine, Ms. Wicks, let's say there was a diamond ring in the fanny pack. Or let's say somebody claims that there was. I mean, doesn't the hospital have an interest in having its special police officers make an inventory of whatever was inside the property? So when the bogus claim of the diamond ring in the fanny pack comes, there is a record already prepared that there was no such item there, such that the hospital is able to rebuff claims that its people, you know, whoever maintains the property room must have stolen the diamond ring. This is not difficult to understand for me. What's your response to that?
Well, and my response to that is they don't outline it as a basis for their policy. There's no differentiation of when, according to their policy, he should be looking for valuables for any. Yes, the valuables are put in an envelope as opposed to the bag, but it talks about the property being stored in a safe and keeping it protected. That's part of the policy. But there's no separate policy for if you find valuables or if it's just property.
Well, in any event, the special police officer testified based on his years of experience at the hospital about why he conducts the inventory search. I believe he said something like it's to safeguard patients' property and protect the hospital against claims of loss or theft. What's wrong with that?
It still has to be reasonable, and there's nothing in their policy that allows for that. The policy allows for putting the property in a safe, which is clearly going to safeguard it from, and you know, if the hospital's policy is we take your property, we put it in a bag and we lock it up in a safe, that should safeguard the claim of that there's a loss from the property. I mean, you
mentioned earlier that you thought it was, I guess, suspicious at the very least that the special police officer collected property from the trauma bay where appellant was being treated, but not from the trauma bay where the woman who was more critical was being treated. I have a vague recollection of some testimony by the special police officer, perhaps you recollect it better, where he said he saw he explained first of all that sometimes he and the other officers sometimes get calls from the medical unit, such as the ICU, that there is patient property to be retrieved, and they respond to that. But that regarding the trauma bay, he goes there on his own and looks to see whether there is property that has been discarded. Well, discarded is not the right word, but taken off of the patient's body and thrown onto the floor, for example, so that the treatment team can do its work, and that he went to the trauma bay for that purpose, to collect such property. And I think he said something about not seeing any on the floor in the area where the woman was, but seeing it on the floor in the area where appellant was. Am I misremembering that?
I think you're correct, Your Honor. He indicated that on that day, when he was collecting it from one bay, there hadn't been anything left for him to retrieve in the other bay. He also testified that he would do it separately anyway, because you wouldn't want to mix up property. So, clearly there's some procedures that are not outlined in the policy that Mr. Stokes, perhaps with good reason, is adding to it. But I think that's part of the problem. It's not under these facts, the reason for the inventory is to safeguard the property. There's no reason to go in the fanny pack. When the fanny pack fits in the bag, you can, the bags have sort of a cinch on the top. You can store that in the safe and protect it from loss. And
I don't think the property bags or the clothing bags were stored in the safe. It was the valuables put into envelopes that were stored in the safe. And so you would need to look to see if there's any, so that you could put them in the right place. I'm just not seeing
sure
what's unreasonable about that. In
I'm
any
not sure
event, you noted that the officers, I think you referenced their body cameras. It is true, the video shows that the officers' body-worn cameras pick up the special police officer doing his inventory work. But they pick up a lot of other things too, depending upon which way the officers were turned. What's the significance of that to the whole state actor issue?
I think the issue is the officers are there, and on this record at least, they're not aware of what the hospital policy is. But I think as police officers that are standing there watching over this scene with the person that they're, there's no criminal activity, but there's state action investigating the traffic accident and trying to sort of maintain a status of what's happening with these two individuals. And there's no state reason to be going into the fanny pack. And
Ms. Ricks, can I press you a little more on the state action piece? Because you seem to be suggesting, or I understand your argument to be, that the mere presence of the officers there was enough for state action. And we do have a number of cases where officers have stood by while a private person conducts a private search, and we've not determined it to be state action. It has to be some closer link, some participation, some sanctioning, something more by police officers who may be nearby while a private citizen is doing an inventory search or something. Do you have a case in mind that may illustrate for us how police standing by is converted into state action or imputed as state action for a private citizen?
I think it's imputed for state action because they're not deterring him from searching the items that he's seizing. When there's no, the police are standing there, they know, they don't suspect any criminal activity. No one's even under investigation regarding this traffic accident. You can think of scenarios where that might be a little bit different, but for the police standing in the ER, observing the treatment of these two individuals and watching the person that they know is a special police officer collecting the property that's been placed on the floor of the hospital. I don't think that they can just sit idly by and let the guy search the property.
Okay, well, let's hear from the government, and we will reserve your a couple minutes for rebuttal, Ms. Wicks. Thank you.
Thank you.
Mr. Valdivia, can I just jump in right here and say, do you share that view of when police standing by during a private actor's efforts to search something automatically converted into state action?
Good morning, Your Honor. And no, the mere presence of police officers does not convert a private citizen's actions into a government action. And I'm unaware of any case where this court has so held. By contrast, in Moody, for example, this court has held that something more, as Your Honor has indicated, has to happen. In Moody, there was a private citizen who apprehended a suspected robber, flagged down a police officer, and that private citizen and the police officer engaged in an investigation that ultimately led to the suspect's apartment. And at the suspect's apartment, the private citizen enters, recovers what is the putative stolen property, while the police officer waits outside. And there, this court held that that amounted to government action. The kind of sanctioning that one would expect would convert a private citizen's action into government action for the purposes of the Fourth Amendment. But those Fourth Amendment protections do not apply here.
How is this case different from Moody, where the officers were there and they did bring him in due to a traffic stop or a traffic accident, and they are standing by, hovering by, however you want to characterize it? Why doesn't that amount to the standard in Moody of state action on their part?
Well, there was no investigation in this case. The officer marshal who was at the scene of the accident testified that he was there to gather information about a traffic crash report. There was no offense report. And the officers at the hospital testified that they were there to notify next of kin, or if appellant's injuries worsened or if he succumbed to them. And the trial court deferred to those, the trial court found that those officers were credible when they testified. And this court should defer to those factual findings. So there was no investigation, which is very different from the facts in Moody, where you have a joint investigation leading up to the potential Fourth Amendment violation.
Great, thank you.
And as Judge Farron pointed out, the hospital has a strong interest in safeguarding patient property. I'm unaware of any obligation that police officers must prevent private actors from fulfilling duties under their private policies. That seems inconsistent with how Fourth Amendment jurisprudence has played out. Moreover, there were no assumptions that were elicited in the testimony of the officers who were located at the hospital. They didn't assume that appellant was under investigation, and there were no facts indicating that appellant was a forensic patient under hospital policies. He didn't come in under arrest or secured to an object, and Stokes did not respond as if appellant was a forensic patient. To the contrary, the police officers are talking amongst themselves in this semi-open trauma bay where appellant was receiving emergency medical care. And Stokes, seeing that the clothes have been cut from this patient and placed on the floor, does what he is required to do under that private hospital's policies. He collects them for the purpose of safeguarding them. And while the officers are talking to each other, they testify that they're not having a conversation with Stokes. They're merely engaged with one another. And Stokes testifies that he was not under, that he was doing this pursuant to the hospital policies. Stokes collect the belongings and moved roughly 15 feet away from the officers before he performed his safeguarding protocol, his administrative inventory. And it's only upon finding the suspected contraband that he waves over the police officers to inform them, to alert them that there may be suspected contraband there. That is really where the case ends. And it's as simple as that. There is no government action here, and really no need to go further than that finding. This court can decide this case on that alone. And unless the court has further questions, the government respectfully asks that the court affirm the judgment of the Superior Court.
All right. Thank you, Mr. Valdeva. Ms. Wicks, we reserved 2 minutes of rebuttal time for you.
Yes, and I think the problem with this case, and really compared to all the other cases, almost all the other cases cited by either party, there's no criminal investigation here. There's no criminal activity that anyone is suspecting when appellant is brought to the hospital. So I don't think we can say it's reasonable for the hospital to be going into people's closed containers. I think that actually makes the risk of theft greater rather than the safeguarding that this is supposed to be for. If they had some policy about things, if they had a policy about what can be searched for valuables, then that may make sense, but they don't even have that. It's apparently just up to Stokes to determine what he wants to look in for valuables. And he decides to open up the fanny pack. I don't think the government has pointed to a reason that the fanny pack needed to be open as opposed to being put in a property bag for safeguarding. If that's what the reason is for this whole inventory. And I think it does get into what does inventory mean? If they're just, and I think they're really just listing what his property is, pair of pants, fanny pack, pair of shoes is the inventory of his property. You don't need to go into things to determine what else there is.
I guess what we're missing here, though, Ms. Wicks, is how that converts what the police did here. I'm sorry, what the special police officer did here into state action. The MPD officers were standing nearby while he, the SPO, conducted what you say is an unreasonable search. Does that somehow turn what he did into state action?
Because
they're standing by and not responding to it turns what he was doing into state action?
I think it's a problem that they're not, they're responding to the hospital. They're with the person whose property is being seized. And so that's what I think turns it into state action. You know, unfortunately, since writing this brief, I've been to the MedStar emergency room twice now. And, you know, I luckily for me, I guess I was not, there were no police watching what was going on. But, you know, I think many of us have the experience of going to the emergency room or going to the hospital where you have the big bag to put your patient property in. And I don't think that we would be thinking, oh, they're going to open up my purse, they're going to open up my fanny pack and look through it. There's nothing under these facts that I think allows for that to happen, with MPD standing by, watching the seizure and not saying anything. And there is case law that talks about that it becomes state action because the police are there and they don't deter the person from doing what they're doing. And this is not a private citizen. This is a special police officer who has the jurisdiction to arrest. But I don't think that allows him to open up closed containers.
And what case are you relying on for this?
The case that talks about that state actors would have, I think they have a duty to deter what would otherwise be a violation of the Fourth Amendment.
Well, your argument is kind of circular. There is no violation of the Fourth Amendment unless the special police officer is a state actor, right? But you're saying that the fact that the police officers didn't deter him from what he was doing turned it into state action?
Well, I think there's two issues. I think the inventory policy of the hospital has to be reasonable under the Fourth Amendment, and I don't think it is. I don't think this hospital policy is reasonable under the Fourth Amendment when we're not giving any we're not giving a precise reason or precise policy as to when you search things for valuables, when you open up things to look for valuables.
But how does the hospital become subject to the Fourth Amendment strictures? It's a private hospital.
Well, the government's arguing that the inventory was, I mean, they were, I think it's a confusing situation because the case law about inventory searches, does that apply to, then they're saying, well, this is the inventory search, so that's why it's okay under the Fourth Amendment. So I think if you start with the fact that I think
it's not okay if there isn't an arrest, is there?
Right. And that's the problem here, is there's not even any criminal activity under these facts. There's certainly other cases where there were traffic violations, and so then the inventory search was upheld by this court.
Well, are you saying if there were not any MPD officers there, you'd have no problem, right?
No, I think my first position is I would still have a problem because I don't think that under this hospital's policy that they've set out when the special police officer can search closed containers. And, you know, I don't think we consent by going to the emergency room to someone at the hospital searching our purses, wallets, backpacks, or fanny packs, or cell phones. I mean,
well, maybe that's a civil action against the hospital if something's missing, but it just seems to me if you don't have these police officers there, you've got a purely private situation unless you deem an SPO to be the equivalent of an MPD officer.
And I think under these facts, he is the equivalent because he's not a security officer. He's a special police officer licensed by the state. And he's there doing this with an MPD is on the scene, checking out what's going on. While they're not, I agree that there's no evidence that they're telling him what to do, they're also not deterring him from searching a closed container. And that's the problem in this case.
All right, Ms. Wicks, we take your argument. We thank both parties for their briefs and arguments today in this case, and the case will be submitted and taken under advisement. Thank you both, counsel.
Thank you, Your Honor.
Yeah, you're free to exit our virtual courtroom at this time. We have one final case remaining.
Thank you, Your Honor.
All right, good morning. Good morning, counsel, Ms. Daniels and Mr. Seybold. This is our third and final case for oral argument today. Harry Crews versus United States. Our counsel ready to proceed?
Yes, Your Honor.
Yes, Your Honor. Good morning.
Good morning. All right, Ms. Daniels?
Yes, thank you. May it please the court, Mindy Daniels for appellant Harry Crews, and I'll reserve 2 minutes for rebuttal, please.
All right, thank you.
I want to make some points about the body-worn camera video that is with the court and some trial testimony, because that's what's going to drive the discussion and the Fourth Amendment issue here. And some points I think are important. So once we get past the point where they saw Mr. Crews exit his vehicle and they pass by and he closes the door a little and leans into the car, they don't see any criminal activity. And the court did find that there was no articulable suspicion at that point, but might cause them to investigate further. So then we get to the point where he disappears and the police reverse their vehicle and they park and they actually go canvassing and looking for him. And when they find him at the top of that landing there that I don't know if the court's had the opportunity to review the video, but at the top of the landing of a number of stairs, and his is the only apartment up there. So when they see him, what the video shows, and I'll just do a very brief transcription of the video because it is very brief. The police officer says, as he's walking toward those stairs, "Hey, what's up? Can I talk to you real quick?"
Just to interrupt you for a moment, is it clear from the record that his was the only apartment up there?
Yes, absolutely.
I thought I saw a reference to him possibly trying to enter the common door to a set of apartments. Perhaps
No.
I'm misremembering that.
You are misremembering that. The police officers walk through a fence. It's pitch black. They see some garbage cans. They see a stairway of, I don't know, maybe it was 17 steps, something like that. He's at the top of the landing and he is the only apartment up there. And in fact, when the officer sees him, and he testified to this, that when he saw him, he saw that he had a key in the door from a lanyard around his neck. And you can actually see in the video, he has a cup of coffee in his hand as well.
Ms. Daniels, could I ask you, if you wouldn't mind, to just take me back 1 second or a couple seconds in what you were clarifying with the record. When the police car backs up, Officer Olivo exits the vehicle. Appellant Mr. Crews has temporarily disappeared from view. Can you just repeat again why those facts there are significant to you in this analysis?
Well, it's kind of like the Hooks case, where they passed Mr. Hooks and then they back up because they thought they saw something suspicious and he was now their target. That's the significance of that, is that they've actually backed up their car. It's 12:30 at night. It was light on the street, but once they enter into the apartment area, it was pitch black. And then what they see is they go along as they have their, Olivia at least has his flashlight on at this point, and the other two officers are right behind him. And I do want to make one correction, though, to footnote one of my reply brief. I said there were 3 white officers and Mr. Cruz is black. Mr. Cruz is black, and in fact, the government put up some pictures for the record on appeal, and it does show that Mr. Cruz is black. There are 2 white officers, and Olivio is from the Dominican Republic. So he's kind of a light-skinned black person. So I did want to correct that I said there were 3 white officers. That was slightly incorrect. So what happens is once they actually see him, or the person they feel was the same person, says, "Hey, what's up? Can I talk to you real quick?" When he says that, he's going toward the stairway. Mr. Cruz is facing his door. The key is in the door from the lanyard around his neck. There's some IDs or whatever hanging from the lanyard that you can see. And maybe Mr. Cruz thought that he was breaking in or something. So he says, "For what? I live right here. I'm going in the house." And at this point, the officer, as he's climbing the stairs toward him, says, "Ah or nah" is what's audible in the video. "Let me talk to you real quick." While he's ascending the stairs, Mr. Cruz says, "For what?" and then turns as the officer is about 3 steps from him. Now, we can't see Olivio's face. We can't see Olivio's face, so we have to rely on what he was projecting to Mr. Cruz by his own testimony. So with respect to the second request, "Nah, let me talk to you real quick." At the suppression hearing, February 4th at page 58, he says his response to Mr. Cruz saying, "For what? I live right here. I'm going in the house," was, quote, "I was like, no, I need to talk to you." He said the same thing at trial with respect to that second question. He says, "When I saw him trying to get into the apartment, then I told him, no, I need to talk to you." So our argument here is that this was letting him know his desire to go into an apartment was not going to be respected, and he was compelled to speak to them. You not only have the reasonable person thinking they were being prevented from going in, but you also have the officer specifically stating by his actions, by what he testified to at the suppression hearing at trial, "No, you're not going to go into your apartment. I need to talk to you." So our argument is that he was seized when those officers started climbing the stairs. Now, Olivio testified at the suppression hearing at page 48, 49, February 4th. "Once I was on the steps, there was nowhere for him to go." Now, he had not seen that bulge yet. The only time Officer Olivio saw the bulge that caused him to race even faster up those last 3 steps was when Mr. Cruz complied and turned toward him. He didn't keep going about his business of what he said he wanted to do. He said, "I'm going into my apartment."
Ms. Daniels, you're saying therefore this was not a consensual situation, right?
That's correct, yes.
And one thing that I want to get clarified here, there were a couple of other officers. Did Mr. Cruz see these other officers coming? Was that part of his reaction, or was Officer Olivo really the only person with whom he was interacting at this point?
You can see not in Olivio's video because he's the first officer, but you can see in the other video that's also with the court, I think it's Government Exhibit A. I think it's Gramieri's body-worn camera video. He's right behind Olivio, and you can see that they're very close to each other. So you would have to assume that if you saw one officer, you would see the other. Plus, there's like in a movie theater, the escalation of it because he could see one and then the other and then the other.
Well, I guess what I'm getting at is whether you're relying on not only Olivio's saying, "I need to talk to you," or "No, I need to talk to you," but he's perceiving that there are 3 officers coming at him and not just one. Or is that not part of your argument?
No, it is. It absolutely is. That all 3 officers were close in step, one behind the other. I think there was some testimony that as well, that they were one behind the other. Olivio was in the lead. Now, funnily enough, Olivio was not the one that even saw him get out of the car. He was relying on the other officers saying, "Hey, that guy, they didn't see a gun. They didn't see a bulge when he was getting out of his car, leaning into it or anything. But they talked about it when they were reversing, we're going to reverse, we're going to get out. Olivio was in the lead. He never saw any of that. He was relying upon what the other officers saw, but he happened to be the first officer and he was the one doing the talking.
Well, wait a minute. Was he relying on something they said to him as they were coming up the stairs?
That's what Olivio testified to, that he never.
Now, he testified where, at trial or at the suppression hearing?
He testified at both, I believe.
Well, as to that particular issue.
Yes, he was relying on what the other officers saw and told him they saw.
At the suppression hearing.
I'm trying to find.
Well, I guess really the purpose of my question is that for a suppression issue and a ruling, the only testimony that we can deal with is the suppression hearing testimony, isn't it?
No, I think I cited in my brief that the court can take into consideration the suppression hearing testimony as well as the trial testimony, but it was pretty much the same. Olivio did testify at the suppression hearing that he did not see anything that happened at the car. He was in the back seat, but he heard the other officers talk about it and why they were backing up and wanted to investigate further.
Why is it important that he didn't see it himself? I know that your position is that even seeing it, even the other officers seeing it, did not create reasonable articulable suspicion. But why is it important that Olivio didn't see it himself if the other officers told him what they saw?
I don't think so. It's of paramount importance. They were sharing information, but I'm just saying that he had no articulable suspicion whatsoever. He saw nothing. The other officers, the court found it was consistent with innocence, as well as maybe the guy did have a gun, but the court did find that there was no articulable suspicion. The other officers are with him, as he gets out of the car. And like I say, they were one behind the other in a line. And you can see that in the video that's up with the court. So I don't think it's of paramount importance. We always say that what the government knows, it's a collective knowledge. But, he's the one that's saying, I want, he's saying, let me talk to you real quick.
Let me, on that point, Ms. Daniels, how do you respond to the government's argument that Mr. Cruz was not seized because he did not submit to the authority or the attempted show of authority, if you interpret it that way, of Officer Olivio saying twice? The first time it's described as a conversational tone, can I talk to you? And the second time, maybe a little more forcefully, I need to talk to you. And Cruz doesn't submit. He says, no, I'm going in my house. The government argues that is a strong indication that he did not think he was seized and he did feel like he was free to leave. What is your response to that argument?
My response to that is that, and what the testimony, it's Olivio's testimony itself makes clear, is that it wasn't until when he got to the third step, Cruz did turn from the apartment door to meet the officer trying to engage him. So he did comply at that point. I mean, what is the officer really going for here? He's not saying, put your hand. I mean, what is the officer asking for? Okay, I think that's important. Because in the other cases, it's, did they ask him to put his hands up? Did they ask him to pick up a shirt? What is the officer trying to do here? And what the officer's saying is that he doesn't want Cruz to go into his apartment. He wants him to engage with him. And what happens is, by the police action of going up these stairs, Cruz does, at a point where the officer is almost right near him, turn And that is the absolute first time that the officer sees a bulge. He didn't see anything before that because Cruz was turned toward the apartment door. So to directly answer the question, he complied when he turned toward the officer and engaged with him, which was what the officer wanted. He wanted a better look. And he wasn't getting that look if Cruz was going to go into his apartment.
Well, is there room, I'm going to pose an alternative argument and ask you to tell me why this wouldn't work. At the point, if we agree that the government's collective knowledge, I understand what the trial court's ruling was, but the two officers who felt that Mr. Cruz's gesture of turning away from them when the squad car first approached his car was essentially a furtive or suspicious gesture. They back up based on this concern. Olivo is aware of this concern. Why don't we have a basis for when Olivo gets out of the car to say, hey, can I talk to you? Why don't we have enough for at least reasonable articulable suspicion to go forward with a further investigatory encounter? And wasn't that what Officer Olivo was attempting to do? Why did he need to see the bulge first when you had all those other things prior?
Well, there weren't all those other things. There was just the leaning into the car. And the trial court found that at that point, he did not have articulable suspicion. And even the government argued below, he had articulable suspicion when we saw the lean into the car. The court said no. Then the government argued, well, we had articulable suspicion when he was nervous and he showed nervousness when the police first spoke to him trying to get into the house. And the court said no, there was nothing suspicious about that either. So the only, I don't even want to call it suspicion, but the only thing that they had at that point was a guy leaning into his car because his car door was open, on a narrow street. And I think I have a little longer video actually than the court has that goes further. And you can see it's the only apartment. He's very high up. And, he just, he complies with the officer's demand, basically. When he says, nah, he says, I'm going into my apartment. He says, nah, you're not going to do that. So all we have before he sees, we don't have anything until he actually sees a bulge that he thinks might be a gun.
Well, Ms.
Now,
Daniels,
that point is not enough. At that point,
It's not enough.
It's not enough that once he turns around, the officer sees the bulge, and then I guess it advances further into the bear hug. Why can't we start with that moment as a moment where there was reasonable articulable suspicion?
Even if the court did start there and said, okay, when he saw what he thought was a gun, coupled with what he heard the other officers talked about, and that's when articulable suspicion developed. Even if I agree with that, the law does not make a distinction between how long does one thing have to be before another. And our argument is that he was seized before the officer had articulable suspicion. He was seized when those officers, after he said, no, I'm going into my apartment, and the officer expressed dissatisfaction with that and basically said, no, you're going to talk to us. That, basically they had no right to be on those stairs. They completely blocked him. He was trapped. He had nowhere to go.
Ms. Daniels, let me interrupt you a minute here. Did he say, no, I'm going into my apartment before or after the police officers seized him, in your opinion?
He said, no, I'm going into my apartment when they were still walking toward him. So they seized him after he said, "I'm going into my apartment." I mean, that's the chronology.
But before they saw the bulge is your argument.
That's correct. Because if we go on the chronology here, as he's walking toward the staircase, he says, "Hey, can I talk to you a minute?" At
So
that point,
the record is clear that he said no and was seized before he turned and the bulge was seen and he again said no, or whatever it is.
yeah, he said for what, as he turned to face the officer and engage with him, which is what the officer wanted. But yes, the answer to your question is yes,
And
because
was it a no, or was it just a for what as he was jiggling his keys in the door?
what the video shows, he said, and I'm quoting here, and what is very audible, he says, "For what? I live right here. I'm going in the house." Now, maybe that's because
He
Cruz
said
thought-
that, what was he doing at the time he turned toward the officer such that the officer could see the outline of the gun? Was he still jiggling his key in the lock, or what else was he doing? If anything.
he had a coffee cup in his hand, and his key was in the door that was attached to the lanyard around his neck, and he turned with the key in the door.
Did he still have his hand on the key? Was he still trying to open the door?
I don't believe so. The key was still in the door with the lanyard around his neck. So he stopped fiddling with the key and turned to face the officer that was telling him he wanted to engage with him. And that's where I'm saying that's where the compliance comes in. And, so, he did say, "For what? Right here, I'm going in the house." Now, maybe he said that to him because he thought the officers were coming after him, because maybe he thought that they thought that he was breaking in or something. That's not what they thought. They saw, the key in the door. It's a lanyard around.
Ms. Daniels, we lost your audio momentarily. Can you hear us? Okay.
Yeah, yes, I can hear you.
Okay.
And actually, and again, the court saw nothing suspicious about him trying to get into his apartment. So, but for a police presence, he would have just gone into his apartment. And as far as the car thing goes, I mean, I've leaned into my car many times on a narrow street when a car is coming by. Did I have to? Didn't I have to? I did it anyway, just to keep myself safe. I'm sure we all have done it hundreds of times. I don't know if in the video you can actually see the street, but it was a relatively narrow two-way street. I just want to make that point. So, we have a black man who's a target. It's very dark. He indicated he knew it was police by saying, "For what? I live here." I mean, who would respond that way, other than, to a police officer maybe thinking you're doing something wrong. He tells him he wants to go in the house. And as the officer's climbing the stairs at this point, he says, "Nah, let me talk to you real quick." And the officer did say it was a more commanding tone. And like I say, we can't see Olivio's face in it, but he did testify at the suppression hearing and a trial. Either or, he testified the exact same way. I was like, "No, I need to talk to you." And the officer said the reason why he said that was because Cruz looked like he was going to get into his apartment, and that's not what the officer wanted. So in the end of it, the officer got what he wanted. He stopped him. He distracted him enough by his show of authority to prevent him from going about his business and going into the apartment, because at this point he's 3 steps away from the guy. I mean, had the officers stood at the bottom of the staircase and tried to talk to the guy, and he could have gone into, his apartment or not. I mean, the way this situation was, any reasonable person would think it was pretty clear that if he opened that apartment door at that point, the officers were going to follow him right in. I mean, this had escalated from, "Hey, can I talk to you for a minute?" to, "No, you're not going to go into your apartment. You're going to talk to me." So specifically, because I know that what's important here is when did the seizure occur, for my argument, is when the officer said, "No," indicated, "No, we don't want you to go into the apartment. You're going to talk to us." And
Was
that's
there any,
when,
Ms. Daniels, were there any findings of fact? First of all, that the seizure took place before, I'm sorry, did not take place until they saw the bulge in his hoodie. And any findings of fact as to the decibel level of "I need to talk to you"? In other words, was it a command that he would have recognized as a command as opposed to a mere chit chat?
well, it sounds more like, if you watch the video, it sounds more like a demand. I mean, he doesn't yell at him, no, he doesn't say like, he doesn't go, hey, can I talk to you real quick, to no, it's not that great of a difference, but he says to him, hey, what's up? Can I talk to you real quick? And then you hear Cruz's response. He says, for what? I'm going in my apartment. And then what you hear is the officer say, nah. It sounds like that. Nah, let me talk to you real quick. Now, again, we can't see Olivio's face. So what was he conveying to Mr. Cruz with the nah was, and Olivia says what he was conveying was, I was like, no, I need to talk to you. I mean, he very specifically says that that's what he was conveying. I mean, however, if you look at the video, like I said, the decibel level does not greatly increase, as the court suggests here, but he does tell the guy, nah, that's not what you're basically, that's not what you're going to do.
The court does sort of make a distinction, I think, which you can hear to some extent on the body cam footage, that the first, hey, can I talk to you, was in a pleasant, essentially, I don't know if he uses the word pleasant, but in a conversational tone. And I don't think that descriptor is used with respect to the second, I need to talk to you. So
that's correct.
Right. Ms. Daniels, I know you reserved 2 minutes for rebuttal, so let's hear from the government at this point. Thank you.
Good morning, may it please the court, David Sable on behalf of the United States. The trial court did not err in concluding that Officer Olivo did not seize appellant before he observed the shape of the gun in the sweatshirt pocket, and then at that point ran up and seized him. I'd like to just start with a couple of factual points on the record because we've been talking a lot about the facts.
Before you do that, Mr. Sable, I can't recall whether in your brief you concede on the no reasonable articulable suspicion based on the gesture of turning toward the car and leaning into it. Do you in fact contest that determination by the trial court?
No, Your Honor, we argued that below, but we didn't press that argument on appeal. What the court said about that was that Officer Olivo was told by the front two officers that they observed this action consistent with suspicious activity. They'd seen people with guns in the past trying to hide bulges. Officer Olivo testified, and he was credited completely by the court, that the street was wide enough so appellant didn't need to press himself up against the car. And what the court said was that's not reasonable articulable suspicion for a stop, but what it is something that the officers reasonably felt that they needed to investigate. And so they investigated, and Officer Olivo got out to investigate. Turning to what happened, they followed appellant to what he thought was an abandoned building, through a fence, up this stairwell, which gets to the second point that I'd like to address, which is there was no evidence. The evidence at the motions hearing was that police had confirmed in a database that appellant lived somewhere in that building. The testimony at the trial, appellant's mother testified that he lived in an apartment in that building. There was no testimony about how many apartments were in there, which apartment he occupied, or how many apartments came off of that the door at the top of the landing. Secondly, I think Judge Farron was asking some questions about how far the other officers were behind them. Officer Gramieri's body-worn camera Exhibit 8 was admitted at the motions hearing and shows that the second officer was at the base of the stairs when Officer Olivo made physical contact with the appellant. So that's about 10 to 15 feet. The second officer was 10 to 15 feet behind. It's also clear, contrary to what appellant says in her brief, that Officer Olivo was clear that he did not start running at appellant until he observed the shape of the gun. He was walking up the stairs, and then when he saw the shape, he was concerned for his safety, immediately recognized it to likely be a gun, and that's when he raced and gave him the bear hug. I think Judge Thompson was asking a question about what appellant was doing at the time Officer Olivo was talking to him, and that on page February 4 transcript, page 51, Officer Olivo testified that he was still trying to get his key in the lock at that time. So even as he's turning to the police officer, he's still scrabbling at the door with his key. He's still trying to get through that door. The last point that I would make is that this is an objective inquiry, of course. The Fourth Amendment inquiry is objective here, but appellant did say that he had no prior contact with the criminal justice system before this. The pre-sentence report shows that he was arrested in 2012 for ADW and simple assault, and in 2015 for arrested with a gun.
Yeah, but did the officers know this? I mean, why is that relevant for our purposes here of trying to determine whether the officers had a basis to follow him up his steps and, as appellant's counsel argues, essentially corner him in front of his home, that he clearly stated he was just trying to go home?
You're absolutely right, Your Honor. It's an objective inquiry. A reasonable, innocent person, the officers would have no way of knowing what his record was. I just wanted to correct that record point because it was in appellant's brief. With respect to what the Officer Olivo said, he was credited by the judge, and you'll see from the video, and he testified that he said in conversational tones, "Hey, what's up?" And you can hear on the video, appellant says, "It's for what? I live right here. I'm going in the house."
Was that the first time that Officer Olivo had approached him, and that was the response, right?
Yes, there's two exchanges, Your Honor, two exchanges before the RAS. And again, appellant doesn't brief a claim that the court erred in finding reasonable articulable suspicion to frisk as soon as he observed the shape. That's not a question for this court on appeal. The only question is, was he seized prior to Officer Olivo seeing the shape of the gun? And there are two exchanges. The first exchange is what I just read. "Hey, what's up? For what? I live right here. I'm going in the house." And the second exchange is on the video. "Let me talk to you real quick." And the answer is, "For what?" Now, in the court, Officer Olivo characterized this second as, "No, I need to talk to you." And the court can credit that. The trial court credited that, and this court could rely on that. But you can see from the video that that's clearly not what he said. He said, "Let me talk to you real quick." But in any event, there were two exchanges. And then at that point, Officer Olivo starts to ask a question. Appellant turns slightly. Officer Olivo sees the gun, and he sprints up the remaining 3 to 4 stairs and gives him a bear hug while appellant is still trying to get through the door. I don't know where the coffee cup came from. There's no testimony about a coffee cup. I didn't see a coffee cup in the video, but he's still trying to get through the door at that particular time. Under the totality of the circumstances, appellant was not seized. We know there's several different factors here. And again, of course, the court's looking at it from the totality, but let's just take, for example, the exchanges. We know that two conversational exchanges, even if one is somewhat more urgent, Your Honor, do not transform a consensual encounter into a seizure. We have
Wait a minute. On the one hand, the officer did not say, "Don't move," or "pull a gun," or anything like that. On the other hand, you can say to some extent it was a command, but I think you can also say in any event that in the physical location of all this, wouldn't a reasonable person in Cruz's situation, perceived that he was cornered and almost desperately trying to get into his house. He can't get the key to work. A cop's coming at him. Even without the question of whether the L-shaped bulge in the hoodie had been seen, isn't that enough for a seizure? Once the individual perceives that he's cornered, if that is the way it would have been found, if there had been a specific finding of fact on was he cornered or not. I'm just trying to say the circumstances. It's dark. Police officers are racing up the steps toward you or walking up saying, I need to talk to you. You say, I don't want to talk, in effect. Isn't all that a seizure prior to observing an L-shaped object in the hoodie? I mean, that's the argument. I don't know.
Yes, I understand. And this case was the case. The answer, I would say the answer to that is no, Your Honor. The case is that appellant relies on Dozier, which was decided after the trial court decided this case. The court also has the Albert Jones case from 2017. And then there's an older case called the Lawrence, which we also cite. And those, all three of those are alley cases where the defendant is hemmed in or pinned. But in each of those cases, Lawrence, there was no seizure. That's a case where the officer talked to the defendant in an alley. He it was only 3 feet wide, and he asked him a couple questions, and he was not seized. In Dozier, for example, the court will recall there were 4 officers, 2 that were out of the car, 2 that were at the end of the alley. But there were many more exchanges in Dozier. There was 2 requests to talk to Mr. Dozier, and that he eventually complied. Then it was a request, could we see your waistband to make sure it's clean? He shows them his clean waistband. Then it was, can we?
Well, I'll acknowledge that there was more interaction, but let's turn it around. Your premise that this is a consensual encounter as opposed to a forced encounter or a commanded encounter. And it's hard to see under these circumstances whether, if I'm right with the consensual encounter analysis of what you're saying, that he was consenting. Now, does that not make a difference? If he was resisting, can there be no seizure until they saw the lump in the sweatshirt? I mean, there's kind of a disconnect there, it seems.
Well, the inquiry, it's called a consensual encounter, but it doesn't require affirmative consent. The inquiry is whether a reasonably innocent person, as the court's well aware, would have felt on the basis of the police conduct that he wasn't free to terminate the encounter or go about his business. And here, we have a number of instances in which the case law shows that this isn't so. A reasonable person in his shoes would not have felt that he wasn't free to go into the apartment building. And of course, we know that he was still trying to do that, and he did not.
It seems to me, though, that there was testimony from Officer Olivo that indicated Olivo felt he had no place he could go. I mean, he implicit in that was a perception, I gather, that he couldn't get into the house, or he was having a hard time, or he certainly may have been technically free to leave, but he couldn't get anywhere. He'd have to jump over a railing, or he'd have to run right past the police officer on the stairway. I mean, you have this picture at night with a flashlight going of his being cornered and without his permission, and saying no, in effect. And it's hard to know what to do with that, simply to say this is not a seizure before he turned to the officer to reinforce his saying no.
Well, I think it was moving in that direction, Your Honor, but we weren't there yet. The officer was ascending the stairs, asking to talk to him. He could have gone through the door. He could have said no, he didn't want to talk to the police. He gave an equivocal answer, which was for what? It did not approach the level of police conduct that this court has found to be coercion in Albert Jones, which of course was the case in an alley where police asked for his identification and then told him they were going to run him for warrants. And that was the pivotal event that suggested to Mr. Jones that he was not free to leave. And then in Dozier, the officers repeated questioning, the showing of the waistband. Can I talk to you? The showing of the waistband, and then can you put your arms up against the wall for a frisk? That's what led this court to conclude that he was seized. We simply weren't there. It was 2 requests asking to talk to him. And as recently as the Valerie Brown case, we have those 2 innocent requests aren't sufficient to connote a seizure. We don't have these exact facts in this jurisdiction, of course, because it is the alleyway.
That's why we're on the regular calendar. I mean, we have unique facts, and this is going to be the Cruz case, not the Dozier case, and it's just very hard for me to see that a reasonable person in this situation trying to get into his home, who twice tells a police officer, in effect, I don't want to talk to you, and at that point hasn't yet revealed that he's got an L-shaped lump in his hoodie. And if that's what the facts are, that's what gives me trouble. Obviously, with the L-shaped hoodie, that's a slam dunk once he sees it. But the real issue is, does he feel sufficiently hemmed in, or whatever verbs you want to use, at the point of before that to impute to the police officer, to the government, that a seizure has taken place?
Well, I would turn then in the alternative to the argument that he had not yet submitted. We have several opinions. There's the Plummer case and the Pridgeon case, and also the Waterman case that we cited. We know at this point that he's at the top of the stairs. He's still scrabbling with the lock. He's trying to get through there. He's saying, for what? So he's rebuffing the police officer's request to talk to him. And all he does is he makes a slight turn to the officer, but he does not agree to talk to him. He's not complied with any requests from the police officer. In the Plummer case, the police are pointing guns at Plummer. It's very coercive, telling him to put his hands up. He's still reaching towards his waistband. He is not seized. In the Pridgeon case, which was written by, I think it was the exact same panel, it was 4 years ago. It was the 3 judges on this panel. Appellant was trying to get through a doorway, and the police told him to get on the ground, but he was still trying to get through the doorway when they were pointing guns at him because they chased him into an apartment building, suspecting that he had a gun. He didn't get down on the ground, and he was not seized, even though guns were pointed at him. Under those 2 cases, appellant is clearly not seized here. No matter what you think about the circumstances of the darkness in the alleyway, appellant was not complying with any request to speak to the officers. And so on that ground alone, the Fourth Amendment decision by the ruling by the court should be affirmed.
Well, in Dozier, though, the court seems to indicate that what may have started out even with a show of authority to which the appellate doesn't comply, that there was a seizure by the time he actually complied, right?
Well,
aren't those more similar to the facts we have here?
Well, but the difference, and another difference between Dozier and also the Hooks case, which is the guy sitting in the chair in the sidewalk that's fenced in, is that both of those defendants complied. They clearly complied. So in Dozier was 4 officers in a dark alley. Can we talk to you? Doesn't say anything. Can we talk to you? Yes. Show us your waistband so we know it's clean. Shows the waistband. Okay, can we frisk you? Yes. Put your hands up against the wall. Now he's seized. That's 3 or 4 instances of compliance with police commands. We have none of that here. Not only are there many more exchanges in Dozier, that goes to whether the police conduct shows that a reasonable person would feel that they were not free to leave, but it also goes to the submission or compliance. So we think Dozier shows on both grounds why appellant wasn't seized in this particular case.
You're saying, in fact, that if he had not turned and he had unlocked the door finally while the police officers were patiently talking to him and then entered, the police would have given up and gone home. Maybe they should have. I mean, there was no basis for doing anything, right?
If he'd gone through the doorway, well, I'm not sure I quite understand the question. If he'd gone through the doorway, he was still free to do that at that point, to go through the doorway. He was
Yeah, but he
attempting to go.
He couldn't. He apparently had been trying for some time. The officer said he couldn't do anything, in effect, as I read the testimony. But I'm just asking you hypothetically, if he had managed to get the door unlocked, open before he turned to show the lump in his hoodie, and he finally gotten and walked in, the police would have had to go home. Is that right?
Well, they would have had to do something which probably would have resulted in his being seized. But he wasn't seized at that point. He could have gone through the doorway. He could have said, no, I don't want to talk to you. He could have turned around and walked back down the stairs. At that point, the police officers hadn't done anything to foreclose those opportunities or to suggest to a reasonably innocent person in appellant circumstances that he wouldn't be free to do that. Obviously, he felt some pressure. In all these cases, there is some pressure that the defendant feels. We know that. And Judge Farron, in the Barnes case, which you wrote, it's probably been 30, 35 years ago, but you talked extensively about this, about why it was, about how courts had to balance this. One of the things that you said was, it would appear that in these cases, the court increasingly has opted in favor of public safety. It has done so by electing to raise the threshold of what is meant by a seizure rather than deciding to lower the standard for the minimal level of objective justification required to validate the detention or seizure. In sum, in the interest of permitting the police to do their job consistent with individual rights, the court apparently has found it preferable to deem non-intimidating police questioning a consensual encounter, not a seizure, rather than to risk justifying seizures based on marginally suspicious circumstances which are capable of innocent explanation. So there is.
I hope I've gained some wisdom in the last 35 years. That's what I said.
Well, the fact is, Your Honor, what Judge Beck recognized and what the Supreme Court recognized and what this court has recognized is that these encounters are an essential part of police work. They're valuable for ferreting out crime. And in fact, I would say that what Officer Olivo here did is what we want our police officers to do. What was he supposed to do? They saw suspicious activity, which was not itself a basis for a stop, but he suspected that there was a gun. He got out of his car. He followed. It was appellant who led them into this dark stairway. He followed and asked to talk to them. He was reasonably investigating. He wasn't coercing anybody. He wasn't putting anybody in a bad position. He asked to talk to him. And so this is what we think we want police officers to do. This was very good police work, I would submit.
All right.
So
Mrs.
when I asked you initially whether you defended the trial court's ruling that there was not reasonable articulable suspicion, you told me, well, the government hasn't pressed that in its brief, but just now you said there was no basis for a stop. So do I take it that the government's position is that there was no basis for a stop when they saw him pressing himself against the car?
Well, we didn't argue it. I think it's unlikely that this court would find that that was enough under these circumstances, Your Honor.
All right. Thank you, Mr. Sable. Anything else?
May I make one more point, Your Honor? And I would simply say this. Thank you. We argued in the brief that even if this court were to find that the trial court erred in its Fourth Amendment ruling, that application of the exclusionary rule would not be appropriate under these circumstances. There's no indication that there would be appreciable deterrence by suppressing the gun recovered by police or the statements here in this matter. As I just articulated, Officer Olivo did what we would want a police officer to do. There wasn't any, he acted in good faith. And so for that reason, we think under the cases that we noted in the footnote on page 18, that the evidence should not be suppressed in any event.
All right.
And for those reasons, we would ask that the judgment of the Superior Court be affirmed.
All right. Thank you, Mr. Sable. Ms.
Thank you,
Daniels, you reserved a couple minutes for rebuttal.
Yes, thank you. A few quick points based upon what the government said. Mr. Cruz had no prior convictions. There were a few arrests, number one. Number two, the court did make a finding of fact that it was not reasonable for the officer to presume that the building was abandoned. She did make that finding of fact. And also going back to the video, what the government is leaving out is before that officer made the second statement, said, "Let me talk to you real quick." You hear on the video him say, "Nah." And then you have the officer's testimony of what he thought he was saying, which was, "I told him no." So I think that between the "nah" and "I told him no," we know what happened. I think that this case is very similar to Hook's, very similar, except even worse, because, you know, he's not sitting at a barbecue. It's pitch black out, you know, and just very different situation. He's truly penned in here, and there was nowhere for him to go. The other thing is that Dozier, I want to go to Dozier for just a moment. Dozier says, and they quote this, even after the second request, before all that other stuff happened, upon the second request, Dozier says, "We think it's highly unlikely that a person in appellant's situation would reasonably have entertained the prospect of continuing to walk away in that scenario between two sets of officers who had made clear their intention to engage with him, and Woody had felt free to disregard the police presence and go about his business." And that's exactly what happened here. The officer made clear his intention to engage with him. He did not feel free to disregard the police. And that's why, you know, he either has to be facing the door and trying to go into his apartment, and when he turned, clearly he had to stop doing that in order to turn. You can't do both at the same time. You can't be facing the door and trying to fiddle with a key and at the same time turning enough for the officer to see the front of a hoodie. So
I'm not sure you can, but go on with your argument. I think you probably could do both of those things at the same time.
Well, you see that he's looking at the officer at that point. He's not looking at the door at that point. I mean, things do happen quite quickly. But I mean, as far as the compliance, you know, had he gone about his business, he would have just kept facing the door and gone right in his door. So clearly he complied by turning toward the officer, you know, when he was a couple of steps from him. He got the officer got the attention that he wanted.
Well, Ms. Daniels, let me just ask you this. If he complied by turning, and at that same moment, the hoodie L-shaped item was disclosed, how does that cut? Is that sufficient for reasonable suspicion?
Well, I'm not arguing here that that was not sufficient for reasonable suspicion at that point. And again, what I'm arguing is that he was seized, clearly seized, upon all the circumstances, everything that the officer said, what a reasonable person would think before he even turned. And before that articulable suspicion came into play. And that's the important point here is, you know, when was he seized? Was he seized when the articulable suspicion was in place? Or was he seized before that when the officer has let him know that it's not okay for him not to engage? You know, we don't want you to go in your apartment. I want to talk to you, even though he indicated he wasn't. And I would say, you know, the government makes much of what do we want police to do? Do we really want officers to follow Black people from their cars with no articulable suspicion, target them, see a Black person with their key in the door from a lanyard around their neck? It's clear they're not breaking in, whether that led to other apartments, whether it was his apartment or not, and stop them and force them to engage with police when they are clearly saying they don't want to. All he could do was say, you know, I'm going into my apartment. He stated his intention very clearly, what he wanted to do, what his business was. And the police officer, you know, responded, nah. let me talk to you real quick as he's going up the stairs. And you can see all that in the video. But the government does completely leave out that it sounds like or nah. And I'm going to go with the nah because the officer said at the suppression hearing, I was like, no, I need to talk to you. And that's what he was indicating to him. And again, we can't see his face. Presumably, I don't know if Cruz could see his face or not, but the officer did say what he was conveying to him with his second statement. And so, at that point, Cruz, you're right. I mean, he had a choice of, does he completely ignore the officer and go into the apartment? It's pitch black out, it's night, no one else is around. It's only these three officers and him, and risk the officers going into the apartment with him, or, does he comply? And whether or not that compliance was, the officer got his attention. That's what he wanted. He wanted him to engage with him, and that's what he got by the police show of authority and showing that he was dissatisfied with his first response. It escalated. It escalated from, hey, can we talk to you, to you're going, to talk to us, climbing up the stairs and not allowing him to go about his business. And is that what we really want police to do? Is that their job out there? And I would disagree with the government. I don't think this is good police work. And I don't think this is what we want police to do under circumstances as presented here. And
Right.
so I would say that there was a Fourth Amendment violation here, and that the fruit of that was the statements and the gun. And also we made a second argument that I didn't have time to argue, but even if there was no Fourth Amendment violation, this was not felony CPWL, but misdemeanor based upon all the arguments that we made in the brief on that.
All right, Ms. Daniels, thank you. And the court thanks both counsel for your briefs and arguments in this case, and the case is submitted. Thank you, and you're free to leave our virtual courtroom at this time.
Thank you.
Thank you very much,
for your
Your
time
Honor.
today.
This
Thank you.
honorable court is now adjourned.